The memo is allowed today, my lord. And last date of surrender 27 my lord. Memo is allowed, but due to the
All right, I'll be it.
Relaxation of the terms and conditions of
One memo.
I have pardon to mention my modification of order.
Modification by mention memo
my lord submission of note of submission at
note of submission.
My lord, one tied of matter.
Written note or say file नहीं रखते हो.
Yes, simply partition.
Yes, yes. Yes, yes.
For partition. Second.
Suit for partition.
Partition पे reversal judgment पे मैं ask
What is the urgency?
next week.
What is the urgency?
Urgency.
Return the memo. Balaram, return the memo. Second appeal memo, return it. Return it. No, will not be allowed. Sir?
Pardon to mention, my lord.
Yes.
I have filed memo today on file number 03315.
Yes, yes. What do you want?
Method last hearing date on dated 6/4/2024. Honorable Court passed order to release the matter when moved, sir. So,
Give a memo, we'll see.
Item 17. Item 17.
17.
Yes. On behalf of Mr. Mahathi, we have taken up next week, my lord. His wife has already expired, so that he is unable to attend this honorable.
All right, all right. Item 17, sir?
Yes, ma'am.
ERP 42 of 2024?
Yes, ma'am.
All right. As per for release this matter next week. Yeah.
Supplementary list item number 1 for judgment.
The result, the writ application is disposed of by directing the opposite parties to consider the case of the petitioner for her engagement as a Sikha Sahayak or in any equivalent post against the existing vacancies, specifically taking note of the preferences cited by her at the time of submitting her application in terms of the relevant provisions of the guidelines referred to here and before, and to issue appointment order in her favor in whichever district she is found to be eligible as per her preference. The whole exercise should be completed within a period of 4 months.
Item number 2 for judgment.
For the foregoing reasons, therefore, this court is not inclined to allow the prayer for bail of Pathani Samantalenka and Abhijit Sanjay Jambure alias Deshmukh. Petitioner so and so. Generally, BL appeal number so and so are rejected. This court is, however, inclined to take a lenient view in respect of the other petitioners. Resultantly, the prayer for bail of Pradyumna Kumar Sahu, Saroj Kumar Naik, Soumya Ranjan Patnaik and Pritam Karo are allowed. Let them be released on bail on such terms so and so so and so. They shall appear before the IIC of STF, CIDCB, Bhubaneswar on every Sunday at 10 AM for a period of 6 months, and such facts shall be certified by the IIC to the concerned court, and so and so. With other conditions. So.
Item number 3 for judgment.
You knew it. It's a chant, and so Malik also knew it. That this is going to be the order. That link. Item 3. Item 3. Thus, from a conspectus of the analysis of facts and law made herein before, this court is of the view that the order passed in the earlier appeal preferred by the opposite party number 6, not having been challenged, has attained finality. Secondly, it is not open to the opposite party number 6 to claim that the ADM did not have jurisdiction to hear such appeal, or that it was premature, as it would be hit by the principle of estoppel, for she herself had invoked the jurisdiction of the ADM. Further, the subsequent appeal being filed challenging the selection of the petitioner also on the ground of a residence is barred by the principle of res judicata. Even the additional ground of the opposite party number 6 securing more marks than the petitioner in the matriculation examination raised in the subsequent appeal would be hit by the principle of constructive res judicata and therefore could not have been considered. Thus, this court finds that the ADM committed gross error of law in entertaining the appeal and in setting aside the engagement of the petitioner as Anganwadi worker of the concerned Anganwadi center. The impugned order therefore warrants interference. For the foregoing reasons, therefore, the writ petition is allowed. The impugned order under Annexure 4 is hereby quashed.
Item number 4, fresh admission.
May I please your lordship, my lord? This is the case of PITC transfer petition, my lord. The petitioner has filed this transfer petition. The proceeding pending for the learned judge family court Kendrapada by the civil petition number 372 by
31 application.
39 application.
Is it challenging? 31 application filed by the husband.
Held by the husband before the
Mr. Naik. Issue notice to the opposite party by speed post. Fixing a short returnable date, requisites be filed by Monday. Huh? Tomorrow is a working day.
No,
Tomorrow,
office.
office must be working. So by Monday, all right, by Monday. List this matter on 17th May.
Item 5.
Public.
Wife is before a lordship minor seeking a direction for transfer of the CP number from Baleshwar to Bhadrak.
Wait, Baleshwar to Bhadrak, how far it is?
My lord,
70 kilometers, what is there?
petitioner, the wife is residing within the Bhadrak.
Oh, she is a doctor.
My lord,
Both are doctors.
both are doctors.
No, no, Duro,
The other cases are pending in Bhadrak, my lord. Initiated by the wife. 125 DB case, police case.
Mr. Behra, this is a 70 kilometer Duro. Only to put pressure, this is being done. All right, you take notice. Dekhe. Issue notice to the opposite party by speed post, fixing a short returnable date, requisites be filed by Monday. List this matter on 17th May.
Proceeding.
In the meantime, all right, further proceedings in CP number 814 of 2022, pending in the Court of Learned Judge, Family Court, Baleshwar, shall remain stayed till the next step.
But speedy post oblique rested.
No. Public, speed post. Sir, speed post could be in.
ନା କରିପାରିବେ ଯେ କାଳେ ତାଙ୍କର ଆଭେଲେବୁଲ ନଥିବ ସେ ଧରି ପାରୁ ନଥିବେ
କାହାର available ନଥିବ ବାଲେଶ୍ୱରରେ ନାହିଁ ନା ଭଦ୍ରକ
ଲୋକାଲ ଏରିଆ
no ସେ ଠିକ ଅଛି
Item number 6.
Item 6. Yes. Pass over.
Item number 7.
May I please, Lord, sir? The petitioner, having graduate qualification, initially selected as non-formal instructor. My appointment is my lord at
This is
annexure.
the Dhananjay this case.
No. Non-formal instructor on of NFE scheme.
କଣ ଶିକ୍ଷକ
Thereafter, he continuing as under EGS. And after abolition of NMS, non-formal instructor scheme, NFS, he was continuing as under EGS scheme as education volunteer. And government issued guidelines for rehabilitation of the retrenched education volunteers at Shiksha Sahayaka. That is Annexure 4 and 5 guidelines.
4 is ଗଣ ଶିକ୍ଷକ such disengaged education volunteer
Minor ଗଣ ଶିକ୍ଷକ. Therefore, Annexure 5 is also to the said effect. I made representation on Annexure 7. Let the
in
authority.
the case of rehabilitation there is no necessary follow no once they become Shiksha Sahayaks through the process of selection as per the existing procedure or
Minor.
so
As per guideline, they make consider my case as humble prayer is minor.
no, how can they consider your case? That is what I would like to know.
The Lordship kindness Annexure
You, because of that resolution of the government,
minor.
the disengaged education volunteers were absorbed as Ganashikya.
Ganashikya.
Now you wanted further to be
No, Ganashikya. I am to Ganashikya.
Ganashikya.
Minor.
But that was long time back.
The Lordship Annexure of that is 2008.
No, that was long time back. That was in 2008. Yes.
Minor.
So what happened?
They have not considered my case. Again, I have made a representation under Annexure 7.
That was in 2009. Dr. Lenka, what are you saying? Grossly bad by limitation. Grossly bad by limitation. I will not entertain this application.
With due respect to Lordship, I only consideration.
This will be setting a very bad precedent. And
My
if I have passed that order, that is a wrong order.
coordinator bench has considered this.
Coordinate bench, then I will release it. You get that order from the coordinate. No, nothing wrong. I will not mind. I will not mind. I will not grant you relief. But if you can get relief from any place, why should I stop you? I am very clear on that.
ମୁଁ କଣ ସେ କଥା କହିପାରିବି ଆଜ୍ଞା
କାହିଁ କହିବି ମୁଁ କହିଦେବି ମୁଁ ଛାଡ଼ିଦେବି କିଛି ଅସୁବିଧା ନାହିଁ further prayer ନାଇଁ ସେତିକି ଥାଉ permission is granted with liberty as aforesaid. Stop it goes without saying that if any such representation is submitted by if the petitioner moves the authority by submitting the representation, the same shall be considered in accordance with law.
OP number 2 collector
The authority, it's a withdrawal there with the order pass kari. मते काहे भूल ऑर्डर टा पास करौछन जति
May sorry, I was letting leave type.
हां हां सॉरी एटा सॉरी तब देखि
Item 8.
एटा सला पे देखि दो yes
May I please, petitioner challenge the impugned order under annexure 4, disengaging the petitioner from the post of Anganwadi worker. My lord, the annexure 4 issue, consequent upon my
as per application number
cancelled.
good
My lord.
there was an order in some appeal
Appeal order ta challenge kari High Court re, High Court
no you were first to tell me the facts you were appointed as Anganwadi worker when
Anganwadi worker in 2018.
2018
My lord. My lord.
is there any engagement order yes
Annexure,
yes so what happened
my lord, thereafter, as it appears, my residence certificate was challenged in appeal, and that appeal was disposed of ex parte. The learned sub-collector directed cancellation of my residence certificate. I have challenged before this honorable court, and this honorable court by the annexure 5 was set aside and remanded the matter to the learned sub-collector by the order dated 22/9/2021. While the 22/9/2021 is in force, my residence certificate is valid, and on 17/1/2022 the disengagement order was passed, ignoring the order of this honorable court. And I have submitted a representation to allow me.
yes what you say
Yes, lordship may direct that
the petitioner is aggrieved by the issuance of order dated 17/1/2022 of the CDPO Boriguma disengaging her from the post of Anganwadi worker purportedly on the basis of order passed by the sub-collector Jaipur in passed by the sub-collector Jaipur on on 22/7/2021 in appeal case number 1 of 2020. The petitioner was engaged as Anganwadi worker of Kuta C Center,
Morad Anganwadi Center.
Morad Anganwadi Center under Ku Gram Panchayat, Haptaguda, under Haptaguda Gram Panchayat. They order dated 1/9/2018. Stop. Her residence certificate was challenged before the sub-collector. In resident, कौन सा था? Before the sub-collector.
miscellaneous appeal was the
In RMC, resident certificate appeal. No, your resident certificate was cancelled.
Cancel in appeal. Appeal case number 1/2020.
Resident RMC resident certificate appeal case number 1 of 2020. Who had filed that appeal?
Appeal filed by one. My lord. Shilamani Nayak.
Filed by one Shilamani Nayak. कौन लिखिला पढ़ला सेक्शन
resident certificate was valid because of functioning RMC resident certificate of the case number 1 of 2023 filed by one Shilamani.
The appeal was allowed and the resident certificate was cancelled.
My lord.
Stop. Challenging said order, the petitioner approached this court in WPC number 27276 of 2021. Stop. By order dated 22/9/2021, this court set aside the order of the sub-collector and directed the petitioner to appear before him on 27/10/2021 with all connected documents and to file his show cause. He appeared.
My lord.
Then
Till yet no order has been passed.
it is submitted that the pursuant to such order, the petitioner appeared before the sub-collector and has filed her show cause.
Right.
But the appeal has not been heard till date. Stop. In the meantime, basing on the earlier order passed in the appeal, the impugned order under Annexure 4 has been issued. Stop. It is submitted that the in all probability, it's submitted that in all probability, the fact of passing of the fact of quashment of the fact of setting aside of the order passed by the sub-collector in the appeal was not within the knowledge of the concerned authorities. Stop. Be that as it may, the petitioner has submitted a representation on 12/2/2024 before the CDPO Boriguma putting forth highlighting all the relevant facts. Stop. Said representation is said to be pending. Said representation is pending. Stop. Considering the fact that the petitioner has already approached the concerned authority, the writ application is disposed of, directing the sub-collector, CDPO Boriguma, bracket opposite party number 4, to consider the representation so submitted and to take a decision thereon in accordance with law after granting opportunity of hearing to the petitioner. Stop. The whole exercise should be completed within 2 months from the date of production of certified copy of this order by the petitioner.
Well,
Pass order.
Item number 6.
Item 6 मतलब similar migration धनंजय जन कलेक्शन कर देइछ
Dhananjay De. Or same order.
Item number 9.
May I please, Your Lordship?
Yes.
and the last occasion Lordship directed to produce certain letters along with all relevant communications between the university and the government. I'm supplying it.
Earlier, the government on the request of the university has also reviewed the proposal and Officer 2009.
Flat market page 7 is page 7 of the
Simply has been regulated by the
finance department.
This is that artist.
Yes, ma'am. Post of artist.
Yes. Yes, please. You want to go through these documents? Yes. Go through. So, as it appears earlier also on 25/7/2009,
The government denied, saying that
the agriculture department informed that the finance department had regulated the proposal.
Yes.
But there was some contradiction that we.
Yes, my lord. In paragraph 9 of the counter affidavit filed by the government, it is, they have stated that the matter relating to creation, abolition of post and appointment made under OUAT establishment is within the purview of the university as it is an autonomous body. So from the year.
So we consider this. You consider this? Take into account this? Because the government has said that notwithstanding the fact that such a proposal was already regulated, government comes up with a counter and states on affidavit that it is up to this to create the post.
That's too little because the post has to be approved because government himself by 2000 in the year 2000 said that the base level post to be abolished, Miller. So out of 5 posts, 3 posts were abolished. So 2 are created and they have been regularized subsequently in the year 2015. So for the 1 post, just a minute, for the regularization of the petitioner, the government university sent time and again letter to the government that the necessary approval may be accorded for creation of a post so that the post of the petitioner can be regularized. Unless the post is approved by the salary, your lordship knows is granted any institution, the salary has to come from the government. The aid has to, financial aid has come from the government. But that is why we sent several letters to the government. That is the position that the government says that is regretted. We have, since it is abolished. The lordship, my last letter, your lordship may see. The in the page 14, your
Government cannot take such a contradictory view.
No, paragraph 8, preceding paragraph 9.
No, Mr. Das, looking at paragraph 9, even if you read along with paragraph 8, I've read it. The thing is that government cannot be allowed to take such a contradictory. On one hand, you regret it. And on the other, you say that it is up to the university to create. And the university obviously will not be in a position to create because of the grant in it. It receives from the government. So there has to be government
Creation of post would be independent of the subsequent grant, sanction of grant in it.
And obviously, there has to be budget provision. There has to be budget provision.
That would be subsequent to the creation. Creation is on the part of the OUAT, which is an autonomous body.
No, creation, any post created as per the rules of business, any creation of post has to be routed through the finance department because the corresponding budget allocation has to be made.
Preceded by a
consent. It has to be. That is the rules of business of the government. Do you have a copy of that?
No.
You must have a copy of that. Rules of business along with the note of instructions.
No,
it will help you to understand the working of the government better. So that is the rule.
The
only thing it can be violated, not violated, it can be overcome is by sending the file to the CM. Only the CM has the power to do it. So this is a contradictory stand. So we are stuck in the middle. So I'll ask you to explain.
Yeah, that was what your lordship had said the other day.
Then you will have to file a further affidavit. Have you filed?
Yeah, let it be again reconsidered by the authority, the state government.
No, I'll keep it pending, but I'll keep it pending. In the meantime, if you can consider, well and good. Yes.
From the year 1998, interview was made. At that period, the vacancies were there. In the year 2000, they abolished the post. When other 2 vacancies arises because of the retirement of 2 artists. And thereafter, Dean has said that there is necessity of 1 post of artist.
Can a mandamus be issued that you create a post?
No, because of negligence.
No question of negligence. It is a policy decision was taken at the government.
How out of 3 persons, 2 persons were regularized. All 3 persons were appointed temporarily in the year 2009. And after completion of 6 years, they have said in their appointment letter, other 2 appointment letter, after completion of 6 years, their service has been regularized, except myself.
Yes.
And in spite of filing writ application, contempt.
No, I will grant you only, Mr. Das, I will grant you only one opportunity since all these correspondence has taken place. What he says, he is saying minus this correspondence. He has a case. He certainly has a case. And at least a legitimate expectation. When 3 persons were on the same footing, 2 have been regularized.
I have been
left out. So he has a point. But the question is, before issuing a mandamus, I'll give you an opportunity. If you can create the post and do it, well and good. As directed, Sri S.C. Rathod Learned Council appearing for the university has produced the copies of the correspondence between the university and the government, including letter dated 25/7/2009, whereby the fact of regretting of the proposal by the finance department was intimated to the university by the agriculture department. In course of hearing, attention of this court is drawn to paragraph 9 of the counter, wherein it is stated that the matter relating to creation, abolition of posts, and appointment made under OUAT establishment is within the purview of the university as it is an autonomous body. Stop. This apparently contradicts the factual developments of the case, in as much as, on one hand, it is the stand of the government that the post is to be created by the university, while on the other, the proposal for creation of post submitted by the university was regretted twice. So, Land State Council is requested to take necessary instructions in this regard and to see whether take his instructions in this regard and to apprise the court appropriately. List this matter on go to Majora go to week 17th May.
Your Lordship, today's order may be a copy of your Lordship's order.
Free copy of this order be handed over to the State Council for compliance. Yes.
Last occasion, your Lordship also directed in last paragraph to explain the contradiction.
ठीक ଅଛି ସେ ଆଉଥରେ କରା last paragraph ମାନେ ତା previous order ଠାରେ.
Last order. 10/4/2024, last order. Mr. Das, AGA is requested to explain apparent contradiction in the stand of government as reflected.
Let me have it from them.
The last occasion also your Lordship.
ଆଉଥରେ କରା ଯାଉ.
15 ବର୍ଷ ହେଇଗଲାଣି ଆଉ 6 ବର୍ଷରେ ସେମାନେ ରେଗୁଲାର
2011 ର କେସ୍ ଫାଇଲ କରିଥିଲେ 2024 ରେ ପଡିଲା.
ନାଇଁ 2000 ହଁ ସେଇଟା ଖାଲି ଗଡୁଛି
ବ୍ୟସ୍ତ ହୁଅନ୍ତୁ ନାହିଁ ଆଜ୍ଞା ଏଠି କୋର୍ଟରେ କେସ୍ ପଡିଲା ମାନେ ସରିବ. ଠିକ. Unless you go to a logical conclusion, how can you pass an order?
Yes, sir.
But even if the court wants to give you relief,
No, sorry. Sorry.
No, don't be sorry, sir. Yes.
Item 10.
May I please, Your Lordship? The petitioner was initially appointed as junior clerk in Chandola College, Chandola renamed as Uddanda Smarak Mahavidyalaya.
How he could be promoted ahead of the petitioner? Or yes, promoted to the post of UD clerk ahead of the petitioner.
That is why, my lord, on the last occasion when I referred to my additional affidavit, a chart has been prepared.
ସେ ଚାର୍ଟ କୁ ଦେଖିକି ତ ଜଣା ପଡିଲା.
Chart ରୁ ହିଁ କୁହାଯାଇଥିଲା that was in compliance to the order of the honorable court in other case, my lord. And today the matter was fixed for reference of the.
That reference, that file has come.
Yes.
Yes, that file has come.
Yes.
Out a last occasion, Your Lordship directed for filing false affidavit. That Your Lordship kindly say their counter. My petition, Your Lordship.
Petition.
That is annexer of 3, my lord.
Yes.
Page 10.
Yes.
Initially, I came before Your Lordship and Your Lordship director considers my case. With the rejected only ground. Your Lordship kindly see page 10, the last 4 lines. As only one post, bottom 550.
Yes.
As only one post of upper division clerk is admissible to the college, and the promotion of the senior most lower division clerk Sri Biswa to the post of UDC and head clerk has not yet been approved by the government. There is no scope to consider the claim of the petition for approval of his promotion to the post of UDC at present. The Lordship kindly see after this order, subsequently that promotion was made by the annexer for with retrospective effect.
Creating a vacancy in the UDC level.
UDC, madam.
Where the other person was, Arjuna Naik was given appointment.
No, that is BC Biswa. Initially BC Biswa.
BC Biswala hegale head clerk.
My lord.
So UD clerk post fell vacant. You were not appointed. The other person, your junior, Arjuna Naik was appointed. That is what I'm saying.
No. They filed a counter stating that BC Biswa was never promoted. in the counter, your lordship kindly see. Why I am saying again, after your lordship's direction, they again file false affidavit. Their counter. Your lordship kindly see. Counter of the opposite party number 1 and 2.
Yes,
Charge 41023.
yes.
That is para internal page 2. Para 6 last 4 lines. 5 lines.
That is
Para
always.
6. Internal page.
Para पढ़ दूंगा, para 6 टा पढ़ दूंगा.
That it is humbly submitted that it is claimed by the petition that he is said to have been promoted to the post of UD clerk with effect from 13-10-85 by the governing body, which is unjust and improper. And the petition of post against LD clerk has been approved and granted a release at the rate of 1/3 with effect from 11-3-88. By erstwhile directed order number so and so. Hence, it is apparently clear that he was allowed to continue in service against the patient of LDC from the date of his joining till
Of his type of office.
of joining till 11-3-88. Therefore, his claim for promotion to UDC with effect from 13-10-85 is devoid of merit. Further, the promotion of senior most LDC Sri Vishwa to the post of UD clerk was not considered and approved by the competent authority.
Just a moment, Dr. Lekha, let me go to that affidavit.
Further, the promotion.
See, you tabular form they say he was approved for promotion to the post of UD clerk from 4/9/85. What is that date mentioned there? See paragraph quoted.
से को approve है नहीं बोले.
Approve है नहीं बोले. अच्छा.
बिल्कुल है नहीं बोले. Consideration है नहीं कि approve.
So date है 4/9/85 रे इठी से कोचो.
हाँ, इठी affidavit देखते 23 रे. Thereafter, your lordship is categorically directed by order dated 21-3-24.
Yes.
To clarify this position, why contradictory assessment? They have stated that why I humbly submit my love with due respect. They have not concealed any information. They have stated instead of saying apology or whatever it may be, they have said not conceal any information. Lordship kindly see their affidavit on 16/4/24.
16/4.
My lord. After your lordship direction letter.
Yes, yes.
16/4
तो nice.
On that statement they have given.
That statement is that 21/3.
16-24 they were affidavit.
16/2/24. 16/4/2024.
16/4, sorry, ma'am. 16/4.
Yes, yes.
The lordship kindly see your lordship's order quoted in paragraph 2 of the order.
Yes.
They have quoted in paragraph 2 of the order, and by explaining, they mention your lordship kindly see. I am reading after paragraph 3 of the order. I am reading. In this context of the kind orders of the courts cited above, initially the Vishwa case, though senior most of all was not taken up for promotion as per resolution passed by the governing body. As ascertained, the resolution was violative of law prescribed under 1963 OMC rules. At a subsequent stage, with a view to complying the kind orders of the Hon'Ble High Court, dated 26/8/23, passed in OCC number so and so, filed by Sri Vishwa, his promotion to the post of UD clerk with effect on 7/2/84 with financial benefit from Ete till Ete, and to the post of health clerk with full salary from so and so by Geo so and so, and direct office order was approved, which was subsequent stage by the office order dated so and so was approved to receive full granting from 1/6/90. Hence, nothing has been concealed in the arguments made in para 6 and 7 of the counter affidavit. How they filed it before this honorable court? There are
you say in that paragraph 6 that his approval for promotion to the post of UDC was never approved. It was never approved.
Never.
But here you say?
No, my lord. Thereafter, para number 7.
Yes.
After para number 6.
In that counter affidavit?
Yes, ma'am.
Yes.
It was placed up to para number 6. But thereafter, what we have reiterated in our affidavit, my lord, that is quoted in the para number 8, it is in compliance with the order of the honorable court.
Yes.
Later on, my lord, and with a retrospective date. That was.
But anyway, fact remains that BC Vishal has been promoted.
Yes. My lord,
Wait. Creating a vacancy in the UD level.
Yes.
That's all?
Yes, that is what, my lord, it has been.
So whether we are not very much interested in BC Vishal. We are interested in the vacancy created by him.
Yes.
Now what happened? Who should have been promoted?
My lord, that is what, my lord, your lordship wanted to see.
Yes.
That when serial number 2 is Naran Prasad Naik, that the present petitioner.
Yes.
And serial number 3 is Arjun Charan Naik. If Arjun Charan Naik could be considered for the post of the UDC, then why not Nayan Prasad Naik.
Obviously, he
And-
could have been considered. He is single.
Our answer in the tabular form, my lord, what we have given. That is, his promotion to the post of UD clerk was given basing upon the admissibility of the post and in compliance with the kind order of the Honorable Court dated 17/4/2017, part in WPC number 6236.
Let us see that order. 6 2
Yes,
3.
That order for consideration, that is,
I have just brought it.
employed my affidavit.
No, I have the entire file.
My lord,
That's why I wanted to see the file.
my lord.
Then it was filed by that Arjuna Charana Naik.
17/4/17 order.
17/4/17. Accountant is UTC or head clerk? Accountant is?
Account is equivalent to UDC. They are mentioned.
Krishna having requisite curriculum. He was completely, he was not a party here. He was not a party to that writ application. The present
The
petition.
present person. My lord, one additional, one affidavit. has
Those
been
are
filed by
the
the petitioner. Yes.
Mm.
And director was to consider. And prior to my case is pending.
There is, so the fact that the petitioner was senior to Arjuna Charan Naik was not brought to the notice of this court in that writ application. That is why the order was, and there is an innocuous order.
But considers.
There is an innocuous order.
And prior
So
to,
the authorities cannot take plea of this order. Authorities know, this court did not know that somebody else was in between.
So, my lord, the compliance of that particular order of the Honorable Court, my lord.
It is not.
That is an unanswered.
No, he was just asked to consider,
Yes, ma'am.
to consider the grievance.
The
They
matter-
never, this court never said,
give promotion.
Yes, ma'am. The manner in, I am not defending anybody's case.
no.
But my submission, my lord.
Yes.
There was an order of the Honorable Court, my lord. There was an order of the Honorable Court.
Honorable court for what? What was the order?
Consideration.
For consideration.
And my lord, Annex 12 series, as it has been submitted by the counsel for the petitioner, my lord, in this case, that the Annex 12 series is the compliance. So in this manner, my lord, the benefit has been extended to a particular person, Arjun Charan Naik, my lord. Now the case of the petitioner, my lord, because he is at serial number 2.
He is at serial number 2. So this fact was not brought to the notice of the coordinate bench by the earlier, by the petitioner, and not also by the state authority. State authority should have said, in that writ application, what I find, he claims that he was working as accountant, but was never approved against that post. Rightly or wrongly, we do not know. It may have been a false statement also. But he never discloses that he is number 3. The state government also does not disclose that the petitioner is there.
I have disclosed in my case that UD first post has not given promotion. They aware that, state government aware that. Because the order was passed in 2004.
Now, what order can be passed now? Yes, Dr. Lenka.
I am discharging my duties as a UDC and given till my retirement.
But there is only one post available, isn't it?
My lord,
There is only one post. It will entail, if you are to be given
accountant is equivalent, accountant post is different, but is equivalent to
equivalent to UDC.
UDC.
So what is the strength?
Different post.
No, what is the staff strength? Approved staff strength.
3 my lord,
One head clerk
one head clerk
and UDC,
and account.
one UDC, one accountant, and one LDC.
And
Please produce it. Let me see. Let me see that. Then it will be very easy to grant you that benefit. It will not entail reverting that person.
my lord.
The only thing is that from which date?
At least that come who is junior got
No, you must satisfy the court. What is the sanction strength? Whatever you have said, is there any order? There must be an order. Staff strength.
because that must be order. But because his post has been approved to accountant, not UDC.
Was there any post accountant? PLFP may be same with UDC.
Accountant post is there. Let the government be clarified that.
Yes.
Yes,
So, Patnaik.
yes. Produce.
All right. Heard further arguments. Sri S.N. Patnaik, learned AGA, referring to the affidavit, referring to the affidavit filed on 16/4/2024 submits that that Arjuna Charana Naik, junior clerk, was promoted to the post of UD clerk, basing on admissibility of the post.
Accountant.
And in compliance of the orders of this court, passed in WPC number 6236 of 2005 on 17/4/2017. The case record of WPC 6236 of 2005 has been tagged to this case. The result of the order dated 17/4/2017, passed by a coordinate bench therein, reveals that said rate application was disposed of, directing opposite bed number 1K secretary, directing the secretary, school and master,
Higher education.
higher education department, to consider the grievance of the petitioner afresh in terms of order dated 8/8/2008, as similar benefit has been extended to similarly situated person. Stop. Be it noted that as per order dated 8/8/2008, the senior most employee, being BC Biswara, had been promoted to the post of head clerk, to the post of UD clerk. 8/8/2008 he became a UD
And subsequently head clerk.
আমার দরকার সেটা
তার head clerk
Dr. Jekeleka argues that BC Biswara was subsequently promoted to the next higher post of head clerk. He further submits that the staff strength of the college admits 4 posts, that is head clerk, UD clerk and accountant, UD clerk, accountant and lower division or junior clerk.
Junior clerk.
According to him, UD clerk is at the same level of accountant. Stop.
And he was promoted to accountant. That is my record. That also
clarifies that Arjuna Charana Naik was promoted and approved in the post of accountant
on 11/6/19.
On 11/6/19. 2019. In view of the submissions as above, the State Council is requested to ascertain the staff strength of the admissible staff strength of the institution, if necessary, by producing the relevant order. Yes. We'll take it up 1 week after.
Yes.
Place this matter on 8th May.
Yes, a copy of the order.
3 copies of this order be handed over to Mr. Patnaik for compliance.
Item number 11.
Yes. This is a part-heard matter.
Yeah. To recapitulate the matter,
Who is opposing you?
my opposing the state. I must concede, my lord, my learned friend plays a very fair counsel, because the affidavit he has given is going to clinch the issue. I will be relying on the affidavit filed by him. Before that, I must have to recapitulate the facts so that my lord will be able to appreciate what I wanted to come.
Yes.
All the petitioners, including others who were there in the earlier writ application, approached this honorable court that they were all appointed as lecturers in an aided college, have been duly approved, and they have been put under the UGC scale of pay, but their scale of pay has not been properly fixed up, while the others are given the benefit by deducting 5 years from the date of their appointment, whereas this has not been extended to them.
because the law has been established by this honorable court that there cannot be a discrimination or there cannot be a difference between the employees of the aided educational institution who were recommended by the staff selection committee or who are recommended by the director selection committee or who are appointed by the management itself. Even the staff selection committee recommends to the management, the director recommends to the management, and all the appointments are made by the governing body itself. Once they are appointed by the governing body, my lord, they became an employee of the aided institution. And after they are approved, they are entitled to a scale of pay as per the gratuity rate. Therefore, a question arose before this honorable court that as to whether there can be a distinction between the employees, those who have been appointed or continuing as an upping means sponsored by the state selection board as an aided employee, and those who have been appointed by the management, and there can be any differential treatment for them or not. That has been decided at rest, that they are all equal in status. They are by class by themselves, one class, employees of the aided institution. They tried to test it before the Honorable Appellate Court, that order. The Honorable Appellate Court affirmed the view expressed by the division bench of this Honorable Court. In that background, my lord, when the petitioners were continuing and they approved this Honorable Court, your lordship can have looked at Annexure 1, the collateral bench of this Honorable Court passed an order on 17/1/2018 at page 23.
Yes.
Keeping evidence, we refer the matter. You also can have come to page 25.
Yes.
It would be better if you also come to page 24. Considering the submissions made by the Learning Council for the party, and after going through the record, this court find that OJC number this filed by Kartika Chandra Mishra, Vishwachandra Sarangi, and Madhav Chandra Mishra, respectively, were heard together and disposed of by common judgment dated 13/12/1996. The operating portion of the which runs as this, my lord. Challenging the said common judgment dated 13/12/96, the state prefers special leave to appeal civil number this, and by order dated 5/5/1997, the said special leave petition were dismissed. Therefore, the common judgment of this court referred to above have been confirmed. In the above view of the matter, applying the ratio decided by this court in the above common judgment dated 13/12/96, this court directs the opposite parties, number 1 and 2, to consider and decide the claim of the petitioner in terms of the said judgment, as affirmed by the opposite party, as affirmed judgment by affording opportunity of hearing of the petitioner, the entire exclusion, etc. Minus on that day also, I submitted now with the cost of repetition. Because of the word consideration, though the law has been established and reference has been given, which is affirmed by the Honorable Appellate Court, the Honorable Secretary thought he is sitting as an appellate authority over the order of this Honorable Court, passed this order. While the matter was heard, and I raised the proposition that you have extended this benefit in favor of the persons who were appointed as aided employees, but you have extended that benefit to them, but you have not given to me. Thereby, you have made a discrimination violating Article 14 of the Constitution of India. Your lordship directed in the last occasion, and they filed an affidavit. Your lordship can have to have the affidavit filed on 12th of April 2023. My learned friend is very fair in that affidavit. That's why I was thanking him.
Yes. Thank you.
You lordship can come to page . From paragraph 3, my lord, 3-4 paragraphs, since I am relying on that, I will have to place it.
Yes.
That the petitioners in the instant writ petition have challenged the Higher Education Department order issued in letter number D dated 7/6/2019, wherein the compliance of the order dated 17/1/2019 passed in OJC number 38387 of 98 filed by the petitioners were rejected, as under Annexure 3, and further they have made prayer in the present writ petition for issue of direction to the opposite parties, more particularly the opposite party number 1, to extend the benefit of career advancement scale of pay as per Annexure 4 in favor of the petitioners by computing the period from the approved date of appointment instead of deducting 5 years from thereof, and to calculate the same and release the benefit under career advancement scheme as per Annexure 4, a statement prepared by the petitioners indicating days from which they are to get such benefit within a time frame. That a detailed counter affidavit on behalf of opposite parties 1 and 2 has been filed on 24/1/23, controverting the averments made by the petitioner in the writ petition. However, on 20th March 23, during the course of hearing, it was submitted by the Learned Counsel for the petitioners that the persons equally placed as the petitioner have been granted relief, whereas the petitioner have been discriminated without any reason and objected. The counter affidavit is silent in this regard. Thus, the Honorable Court directed the Learned Additional Government Advocate to obtain specific instruction in this regard. From paragraph 5, that is the instruction they have given. That as indicated in letter dated 20th March 2023 of the Learned Additional Government Advocate, I don't know what he has written, that though a specific agreement with supporting document is there in the writ petition, which with respect of allegation of discrimination and denial of such benefit to the petitioners while extending identical benefit to others under Annexure 6 series, an affidavit clarifying a first position is required to be filed to appreciate matter of the court, to apply the matter to the Honorable Court. That it is humbly submitted that the benefit of career advancement scheme, the post of lecturer selection state scale, the reader scale is governed following the principle contained in clause 3.7, 3.8, and 3.9 of Government Resolution dated 6/10/89. Here, my lords, my perch. This resolution dated 6/10/89 does not indicate of section 4A and B of section 7C of the Orissa Education Act 69. Therefore, for availing promotion under the aforesaid scheme, a lecturer posted by management, I don't know where from they get that management. That what my lords kindly have underlined, because all the appointments are given by the management. Like Public Service Commission recommends the name to the government, government gives the appointment. So Staff Selection Board recommends the name, the management gives the appointment. Has to consume 5 + 8 years to avail promotion. The lecturers assess and 8 years for promotion to the post of reader scale of pay, meaning thereby 16 years and 21 years initial date of joining for promotion to the post of lecturer SS and reader pay scale up respectively. Here minus may kindly have a mark. In case of SSB sponsored candidates, since from the date of joining, they are availing full grant in aid, being absorbed against the direct payment post, the mandatory period of 5 years is not deducted for them to count their service for the purpose of undergoing career advancement scheme CAS. Thus, in their case, as per provision contained in para 3.7, 3.8 of the Government Resolution of 89, their case is considered for promotion to lecturer SS as reader scale of pay after 8 years and 16 years of their entry into the service respectively. I will explain how the affidavit is incorrect and misleading. That as above on the Annexure 6 to the petition, there is a list of 17 number of lecturers sponsored by the State Selection Board through the advertisement number days, whom 5 years mandatory period from the initial period of joining is not calculated, and they have been given promotion under the career advancement scheme as per the provisions of para 3.7 and 3.8 of the government resolution of 1689. While given, my lord, this is they're conscious that they are given by para 3.7 and 3.8, but they have not incorporated 7Cs 4A and 4B. They have given, if they have given under this, they cannot make I'll come to that provision, my lord. Further, there is a notification of government during this 3/8/2008 containing a list of 18 members of lecturers whose case have been considered for promotion under career advancement scheme following para 3 and 4 of the resolution number 9390 as amended from time to time, and the provisions of Orissa Education Amendment Act 1998 regulating the recruitment and career advancement of teachers of non-government aided colleges. And accordingly, they say we are not entitled. My lord, at this stage, can have a look to what is the provisions prescribed under 7C, 4A and 4B. Of course, they have quoted and they have also annexed in their counter affidavit. You'll also relate that counter page 17 annexure B by 1.
Yes.
This was brought into the statute book by 17th March 1998. Bottom they have mentioned. The Orissa Education through amendment, the 7C of the Orissa Education Act hereinafter referred as Principal Act, after subsection 4, the following subsection shall be inserted, namely 4A. The grantee aid to be borne by the state government on account of placement of a teacher in aided educational institution. Minus my kindly underline aided educational institution. Receiving University Grants Commission scale of pay under the career advancement scheme shall be limited to the extent or may be admissible by computing the period of service rendered by him against an approved post with effect from the date of completion of 5 years of service against such approved post. This is all for so far all the employees of the aided institution is concerned, provided that nothing in subsection shall construed as effect to the seniority, etc. 4B, notwithstanding anything contained in judgment, decree or order of any court of the court to the contrary, any instructions issued, actions taken, or things done on or after the 1st day of January 1986 in record of the matter, providing subsection 4A shall be deemed to have been validly, etc. Now, my lord, 4A, that is 764A, deals with all the employees of the aided institution. There is no mention the categorization of employees of the aided institution sponsor.
Management or SSB?
But anything, madam. Now, madam, can come to the annexures that have been given as starting from annexure 6 series, madam. It starts from page 50. Minus may ignore page 50 because 50 is written because that is the statement I have given. It starts from page 52. Dated 3/5/2008.
Sir.
It contained 80%.
Annexure?
Sir?
Annexure कितने कहले? 6.
Annexure 6 is page 52 of the brief.
52, yes.
52.
3/5/2008.
Sir, this notification is issued by the government because it is not issued by any secretary person or anything, by order of the governor, issued by the government, extending the benefit of grant in aid to these people with effect from 1986, etc. Why I am pressing in my lord 2008, 54, 2009, next page, my lord, 2010, page 58, then your lordship can get it, 64, 2012, all these things, my lord, are extended the benefit of the career advancement scale of pay by deducting 5 years from the initial 75 is 2016. All extended this benefit by law. All are employees of the aided institution. They have made a class to
Deducting 5 years from which date?
from the date of their initial appointment. When they are eligible, after by law, they are initially deducted 5 years. Or I must be clear, my lords. All the employees of the aided institution, when they were extended the benefit of career advancement scale of pay, and when that was sanctioned, they were initially deducted 5 years from the date of their initial approved date of appointment. But all these instructions I am showing, my lords, for them, the career advancement scheme was extended by not deducting the 5 years, taking the date of entitlement from the date of approval and counting the service. Ourselves, themselves, they are all counted, deducted 5 years. But so far we are concerned, the employees, those who have been appointed by the management and approved by the government, this benefit of deducting 5 years was not extended. Whereas that deduction was made for the employees who are sponsored by the state selection board, and thereby, although we are, even persons who are lesser junior to us in the service, they got higher scale of pay while continuing even at the time of retirement. And we have been denied that because higher scale and continuity has been deducted from
in your case, it is from the date of approval.
Yes, ma'am. I'll come to that, my lord, say that a chart I have given. I'll explain that. But before that, let me explain that.
Yes.
These up to 2016, what benefit they have been given. Earlier, they were that deducted 5 years. Now that has been restored back from the date of appointment. Now let us see one of the reasons.
All these persons, they were similarly.
They are all employees of the aided institution.
No. You said that they were initially there. In their case also, 5 years was deducted from the date of approval.
Yes, ma'am.
Subsequently, it was again from the date of appointment.
Subsequently, that deduction was restored back.
But that is not forthcoming from this notification. But
I'm pressing the latest notification that is on 19th of February at page 75.
Page 75.
Can I press it by now?
Just a moment. Let me.
Page 75.
Page 75, yes.
Government notification issued earlier in some cases and other fresh cases regarding placement of teachers in non-government aided colleges of the state government have been pleased to revise the eligibility date, my lord, from the line,
yes,
of their previous placement in the lecturer senior scale and reader scale in respect of SSB sponsored lecturers under career advancement scheme CAS. The following lecturers, etc., my lords, respectively, with effect from the day mentioned against them under the column 4 and 5 of the pro forma below, without prejudice to the claim of others, the placement is made. Where is the mention of 7, 4, 7C, 4A or 7C, 4B, sir? They take a plea that so far the selection board concerned candidates are concerned, we have extended this benefit by taking the approval and reading of section 7C4A. My categorical stand was that I have given the list indicating that they were earlier, the eligible date has been fixed. Now the state government has refixed their eligibility date and previous placement date has been modified to this date, my lord. Whereas so far as we are concerned, the same has been not extended on the plea that you are the management appointee lecturer. But our appointment has been approved by the government. We have been receiving the same scale of pay. There is no distinction between the appointee of management sponsored by the recruited by the management or appointee by the management having been sponsored by the state selection board or having been sponsored by the director selection board. There are 3 categories of employees during those periods, my lord, that one was sponsored by the state selection board, Another was sponsored by the director selection committee. Third was sponsored by the management itself, and they were appointed. But they are all appointed against the sanctioned post. And they were all approved by the state government, are receiving the grantee in the same scale of pay as that of others. And also they were getting the same scale of pay, they are entitled to get the same scale of pay as that of the government servant under Rule 9 of the Recruitment Rules 1974. This was taken into care by this honorable court, which has affirmed that you cannot make a distinction between them.
Yes.
And the order, the latest order passed by the state government is 19th of February 2016, what I have annexed according to my writ application. And this honorable directed the truth here, opposite party 1 and 2, decide the, you take, your lordship consider the case of the opponents. Looking into the ratio decided by this honorable court, affirmed by the honorable appellate court, and pass order. All the matters were placed before the honorable secretary. That all the matters have been placed, they are all identically placed, they are all given the benefit. But at this juncture, your lordship can have a look to the order which I have assailed here.
That is Annexure 1.
Annexure 3, that will be my lordship.
Annexure 3.
Annexure 3, my lord. It starts from page 42. Your lordship can come to the finding he has given. Paragraph 4. At page 43.
Yes.
Carefully peruse the judgment dated 13/12/1996 of the Honorable Court in OJC number 4912 of 1993. In this case, the petitioners have challenged the resolution of the state government. Madam, they wanted to make a distinction between the judgment passed by this Honorable Court, affirmed by the Honorable Supreme Court. He wanted to make a distinction between the order and to come to a conclusion of his own. The petitioners had challenged the resolution of state government issued in this. The state resolution has provided for placement of lecturer in a senior skill after 8 years of service from the date of regular appointment. Regular appointment had been defined in the explanation appended to the state resolution as the date on which the lecturer had come into the grantee fold. The Honorable Court, by order dated 13/12/96, by declaring the explanation appended to the said resolution dated 19/3/90 as invalid and inoperative, had directed the opposite parties to compute the period of 8 years from granting career advancement and other benefits from the date of appointment as approved by the competent authority and not from the date of coming into fold of granting it. I am to see that where that observation is better because I have not been able to get it out. Examine the present case in detail. In OJC number 4912 of 13, the matter of dispute was whether regular appointment would be reckoned from the date of coming into the fold of granting it scheme or from the date of appointment as approved by the competent authority. Whereas this was not the resolution and this Honorable Court decided from the date of approval from by the competent authority. Whereas the present case, the matter of dispute is whether deduction of 5 years of service for implementation of career advancement scheme is correct or not. Deduction of 5 years of initial service for giving granting aid to teachers of aided education institution receiving a UGC scale of pay under the CS has been statutorily provided by the state government through Orissa Education Amendment Act 1998, published in Orissa Gazette by letter number this of 1998. By the said amendment, subsection 4A, 4B were inserted in section C. That is already there. The said provision contained in subsection 4 and P of section 7C of the Orissa Education Act, inserted in 98 with retrospective effect from 1/1/1996, have held their ground for more than 20 years. Granting it has already been provided to large number of lecturers, readers, as per the statutory provision by deducting 5 years of initial service. The petitioners have also been provided granting it against their post as per the statutory provisions after deduction of 5 years of initial service. The petitioners and many other similarly situated lecturers, readers have been given the benefit of granting it as per the statutory provisions without any discrimination. Here I posit there is discrimination because 17, I've shown the orders where the state government has passed the order by order of the governor that the refixing the eligibility. Therefore, the contents of the petition are not to deduct 5 years from the initial service for the purpose of availing granting it as per UGC scale of pay under career advancement scheme is not sustainable as per the provisions of Orissa, etc.
Well,
Minus, I fail to understand. If the law had been established, and as because your lordship gave them a concession, consider, if your lordship directed is that, then he could not have done that. He considered his own way, analyzed the decision of the Supreme Court and my lords to the effect of his own choice. This matter was also considered by a co-legislative bench of the Sonor Court. And your lordship, I am extending a copy of the order. Sir, upon people can see. Your lordship can come to running the state of that document. After analyzing the case in detail and relying on the Honorable Appeals Court judgment of Srivastav case, your lordship opined at paragraph the contentions are stated paragraph 5 maybe. What contentions, my lord and friend? A friend of him also raised the same objection there at running page 9 of the judgment. For contrast, Mr. Sangram Jena, non additional government advocate, made his submission basing on the stand taken in the counter affidavit, while not disputing the appointment of the petitioner as against the first post of lecturer in physics against a sanctioned post on 1/6/1988 and approval of the service with effect from 1/6/1988 in terms of the order passed by this court in OJC number this, London State Council contended that even though service of the petitioner was approved with effect from 1/6/1988, he has otherwise eligible to get the benefit of senior scale on completion of 8 years of service and to the reader scale on completion of 8 years of service in terms of the resolution dated 6/10/1989 under Annex A/1 and subsequent resolution dated 19/3/90. But such benefit due to the petitioner and the similarly placed lecturers appointed by the governing body in non-government aided educational institution was nullified in sections of subsection 4A and 4B of section of the Education Act. This I could not get this that nullification. I could not read it from the section. The learned friend must have read it. It is contended that in view of the provisions contained in subsection 1.
Same thing. We will not go to that. We will go to the finding.
Yes, ma'am. Finding, my lord.
Finding will be at.
Your lordship can come to the finding. Paragraph 8 at running page 18.
Yes, yes.
The submissions made by the London State Council, London Senior Council for the petitioner, contended that even though in terms of the resolution dated 1689.
Sir, we can come to paragraph 9.
My lord?
Paragraph 9.
Yes. Yes, sir. Having heard London Council of the parties and after going through the materials within available on record, it is not disputed that petitioner was appointed as against the first post of lecturer in physics by order of appointment issued on 1/6/1988. Even though service of the petitioner was initially approved by making him eligible to get the benefit of granting aid at 1/3 with effect from 1/6/1989 by order dated 10/7/95 under Annex 2, But in terms of the order passed by this court, in OJC number this, petitioner was extended with the benefit of granting it at the rate of 1/3 with effect from 16988 by order dated 9/2/2000 under Annexure 3. As provided in the resolution dated 6/10/89 under Annexure A by 1 and subsequent resolution issued by the government on 19/3/90, petitioner became eligible to get the benefit of senior scale on completion of 8 years of service for 1/6/88 with effect from 1/6/96 and to the reader scale on further completion of 8 years from 1/6/96, that is 1/6/2004. But as found from the record, in view of the insertion of subsection 4A and subsection 4B to section 7(3) of the Act, petitioner was extended with the benefit of senior scale of pay with effect from 2008 by adding 5 years of from the initial date of appointment over and above the 8 years stipulation. As found from the provisions contained under subsection 4A and 4B of section 7(c) of the Act, such a stipulation was inserted in respect of teachers appointed in non-government educational institution receiving University Grants Commission scale of pay under the Career Advancement Scheme. But as found from the office order dated 18/7/2013 under Annexure 6, the stipulation contained under subsection 4A, subsection 7(c) of the Act was relaxed in respect of lecturers appointed in aided educational institutions on being sponsored by the State Selection Board. But the fact remains that the lecturers appointed by the governing body and lecturers appointed on being sponsored by the State Selection Board are all appointed as lecturers in non-government colleges against the approved posts.
That subsection does not make any distinction.
No distinction. That's why I placed it by law on employees of the aided educational institution. Even though the lecturers appointed in non-government aided colleges were eligible to get the benefit of senior scale on completion of 8 years of service and the reader scale of pay further completion of 8 years of service in terms of the resolution issued by the government on 6/10/89 as well as the 19/3/90. But in view of the provisions brought out under subsection 4A and 4B to section 7(c) of the Act, all such lecturers appointed in non-government aided colleges against approved posts were held eligible to get benefit of senior lecturer and reader scale with addition of another 5 years of service from the date of their initial appointment. Since such restriction imposed with this insertion of subsection 4 and 4B of section 7(c) of the Act was relaxed in respect of the lecturers appointed in non-government aided educational institutions sponsored by the State Selection Board without carrying out any amendment to the provisions by office order number 18/7/13 under Annexure 8, placing reliance on the decision of the case of Aravinda Kumar Srivastava, as we are telling my lord that decision. This court is of the view that the petitioner is eligible and entitled to get similar benefit of relaxation. In view of the aforesaid analysis, this court is inclined to quash the order and accordingly, my lord, that has been granted. Now, the main question is, my lord, as to whether if you have Article 14 will come into operation or not.
Yes.
We are a class by ourselves. You cannot make a class between a class. By making a subclass within the class that those who are sponsored and appointed by the sponsor of the selection, state staff selection board are different than the lecturers who are selected and appointed by the managing committee, though approved by the competent authority, and they are appointed against the approved post, receiving the same scale of pay. But relaxing them, I do not know, because state selection board might be their own favored persons, but management persons are not favored person, for which this relaxation has been discriminated, and this honorable court has directed that you cannot make a discrimination. Most of my own humble submission, till 2016, sir, I have given from 2012 to 2016, series of documents I have given, I had annexed, and the analysis given in the additional counter as a query made by this honorable court, that since they are selection board candidates, we have extended them, and since they are not selection board candidates, they cannot be extended. This is a sheer discrimination, hitting Article 14 of the Constitution of India, and therefore the same is required. Such a right was not never extended by your lordship to them. What your lordship directed? Look here, secretary, you see, decided in the ratio as decided by this honorable court, affirmed by the honorable appeals court. In the decision given by this honorable court, they have taken there is no distinction between an employee belonging to the aided institution having been sponsored by the selection board or not having been sponsored by the selection board. Once they are approved, they are taken to the category of approved lecturer. They are one and the same.
All right, all right. You want to give any reply?
Yes.
Today, I think then I thought because the other matter is there, which is continuing. Again, the senior counsel is also there. You need to give a brief reply. That's all.
I did only to clarify that particular.
Well, let him. How can I stop him from giving his reply if he wants?
Now that is to be clarified.
All right, all right. For further arguments in part, is this matter on next Friday?
Next third May.
Huh?
Third May.
3rd May on that day, only a brief reply. That will
Yes, third base.
3rd May. You are finished, sir?
No, I have finished.
No,
If you lordship want, I can also give a short note on that day.
Yes, yes, that will be helpful.
Yes.
But don't give it on that day. Once I reserve it for judgment, thereafter I will grant you 7 days.
Yes, yes. After the matter is done, I will give a short note.
Otherwise, I will be under pressure to pass a judgment immediately. That will be difficult.
I don't know. এটা স্যার কাজ হইতো দিবি
সেটা ମୁଁ ଗାରଫାର ମାରିଛି
এটা মতে ফেলি দেলে মুটেল মতে
ଗାରଟା ମାରିଛି ସେଟା ନାଇଁ ଯଦି ଆପଣ
ଅଛି স্যার আর ମୋ ପାଖେ ଅଛି ମୁଁ ସାଲ ଗୋଟେ ଦେଇ ଦେଇଛି
ଆଜ୍ଞା
ଓଡ଼ିଶା ସରକାରଙ୍କୁ
yes
I don't know 12.
yes Mr. Das yesterday where did we leave
mine
What I have stated yesterday is the maintainability of this, the petition and the instance.
লেখা টিপার নোটটা লিখলে আবার কোন প্লিজ
The maintainability of the review petitioner on behest of the petitioner there.
that I have understood that point is taken.
That I want to clarify because I have taken my note through that orders in different cases.
Yes.
What leads to this?
Yes.
What they lead to that 5316 and thereafter the review.
Yes.
Why you want to submit here is the first writ petition, thereafter the writ appeal, and then the writ petition where my lord has passed that order, now the review. What is emanate from that order is that my concern is in the writ appeal, whatever it may be, whoever he has demonstrated himself is the entire composite college or a separate college, but after the disposal of the writ appeal, now there exists no composite college. There are two institutions. One is the junior college, one is the higher secondary school. So one is the junior college and other is the degree college. Sorry.
আগর তো আছে কি আগর আছে কি কাগজ না আগর তো yes
Because all the judgment referred to in that writ appeal order,
yes
there the decision was there is no concept of composite college. Even if there was a composite structure of a college having both +2 and +3 wing, now by operation of law, it has to be segregated. And so far this particular institution is concerned, though the honorable single judge has held no, it is Santilata Mahavidyalaya, there is no degree college. So you release the gratinate in favor of Santilata Mahavidyalaya. Now by virtue of the order of the division bench, which has not been challenged to my knowledge. So there exist only two colleges now. It is one is to be known as Santilata Higher Secondary School and other one is Santilata Degree Mahavidyalaya.
yes
In fact, all the communications now from the government or by different authorities or even the college, there has to be two.
no but there must be a government notification to that
Not
effect.
record, because by operation of law that is because the judgment is that. What
No,
was
does the judgment does the
government
judgment
has already clarified that.
correct
What junior college?
no I've seen it but does the judgment clarify specifically that the name has to be this the Santilata High School Higher Secondary School and Santilata Degree Mahavidyalaya? Where are you getting it from?
No. What was the case? Then I am not clear to my. What was the case? Can you see? Only the constant, I will not read out the judgment. Page 19 of the writ petition 5316.
Yes,
1 second, kindly have a glance.
constantly.
My lord.
Yes.
This is filed by one Jatindra Das.
No, that is by Satyalata Jana.
No.
5316.
No. 53 page 19 টা দেখিও। সেই judgment টা যোউটা আসিলা।
Page 19, yes. My Jatindra Das.
Jatindra Das claiming him to be the principal cum secretary of Santilata Mahavidyalaya.
Yes.
And the first line of the judgment, kindly see, page 21. In this writ petition, the petitioner as the secretary of the governing body of Santilata Mahavidyalaya Tikri, district of Balasore, had challenged the notification number 20496 dated 1/7/2009. What is this 1/7/2009 is at page 16.
Yes.
Sorry, 14. Kindly see, annexure 1.
That's Santilata degree Mahavidyalaya.
Santilata degree Mahavidyalaya. So he challenges this notification. So why you are declaring it Santilata degree Mahavidyalaya, notified is Santilata Mahavidyalaya. That was altogether his prayer is. And what was the direction? Kindly see. Say judgment. Kindly see, my lord, page 27.
Yes.
9.
Yes.
The above backdrop, the fact of the case, the opposite party number 1 has notified 13 number of private education institution and aided education institution to receive block grant in term of the provision of the paragraph 3 of the grant order 2004 under hearing list of 13 degree private educational institution, and petition institution was at serial number 1. However, they have reflected the name of the Santilata degree Mahavidyalaya with decree, though there is no existence of such a degree Mahavidyalaya. This is the point, my lord. Therefore, what the court has said like this, rather it was Santilata Mahavidyalaya. Therefore, this court direct the Secretary Higher Education, opposite partner 1, to correct the notification 1st July 2009 in respect of the name of the petition institution as Santilata Mahavidyalaya Tikri in place of Santilata degree Mahavidyalaya Tikri, and release block grant to the staff whose services have been approved by the opposite party.
So this order was set aside.
So this order was set aside. Kindly see the writ of appeal. Page 36.
36, yes.
Para 6. It is not in dispute that the impugned order of the learned single judge has been held to be per inquirium by the judgment dated 8th April 2016 by another learned single judge in WPC 2253012, governing body of Abhimanyu Samanta Singhar College versus State of Odisha. The said order of the learned single judge was approved by the division bench of this court in order dated 6 March 17 in WA number 225 of 16. Governing body of Abhimanyu Samanta Singhar College, State of Odisha and others. As per the impugned judgment herein is concerned, with already having declared as per inquirium and such declaration having been affirmed by the division bench, as pointed out herein before, this court has no hesitation to set aside the impugned judgment order of the learned single judge. Accordingly, impugned judgment is set aside. So what remains now is Santilata degree Mahavidyalaya. After this judgment, now there exists no composite college, because that Abhimanyu Samanta Singhar judgment, my lord, I have see. That was also the same thing. There was Abhimanyu Samanta Singhar College. Thereafter, degree wing was notified under the block grant scheme of 2008. But the principal of the plus 2 college, which was a direct payment college from 1994, he didn't hand over the charge to the degree college. He said it is one college. That is why the case came to this honorable court. And this honorable court directed, no, there exists no composite college. It has to be segregated. And there this judgment was also referred to, this particular 3378. That was referred to, and the honorable court, by taking the other DGBK and that other judgments, Anil Sahu's case, all these things, the court has said this is judgment per inquirium, because it had not taken note of the law. But because it was not declared set aside, it was only held per inquirium. That means the order remains for the parties. Inter parties it remain. For others, it may not be a precedent. That is the point. So that is why I have challenged it. And the honorable court has accepted my submission and have declared it and it set aside it. Now that the judgment is no more there. So that means what effect? The challenge was to the name of the institution, Santilata degree Mahavidyalaya.
Yes.
So now it restored back. So on what basis? Now there are only two institutions. One is the direct junior college, one is degree college. That is the law, man. That is my submission. And that is why the government has issued a general notification, not for this, everybody. Whatever the junior college is there, all will be named as higher secondary school. plus 2 টা যোগ হচ্ছে। And the degree college will be named as degree college. And here is a specific notification for degree college, and that is why now the resolution 17/2009 in respect of the degree college revised. That is why the order passed in the first stage in the Miss case, when the case was admitted, the order was, if you lose whatever the benefit you have taken in respect of the degree college, now the plus 2 college has taken it. Whatever the benefit, you have to return it to the government. That was the purpose. At that juncture, I have come to this honorable court because I was a party. I may not get the beneficiary. But what was my case? There are certain number of staffs. They have to get their benefit of granting it, having been appointed separately for the degree college. So if all these persons appointed through this person who has filed the case, Jatindra Das, if will go strictly, Jatindra Das is the petitioner in that case, though he styling himself as the governing body of the junior college. So in that event, the person, even if the person concerned has get the benefits of granting it, the money is to be returned back by this person who is the petitioner therein. So therefore, since the court has, the single judge in the earlier occasion has accepted that Jatindra Das to be the college, that is the purport of the judgment also. Now that college was also to return the benefit. At that juncture, I have come to this honorable court. I have approached the government. So now it is an order. They have to take steps to get back the money, and thereafter disburse it whoever is eligible. Instead of doing, when they didn't do that, I came before this honorable court, and this honorable court passed that very innocuous order by taking note of the facts. That yes, these are the developments. So you take action on the representation. So at that juncture, if this is the order, now who else could have filed the petition? My petition is with regard to maintainability. On merit, I will come later. Because my senior has placed something on merit, I have also answered.
Yes, you will.
Yes.
That's why I said that he has
Yes,
to.
I am at the threshold. So now who can come to this honorable court? Now, if the money is to be returned, it is to be returned by the, strictly, it is by Jatindra Das. I have met the Jatindra Das party here. In the writ petition, kindly see, though it was disposed of by the administrator, but he has a party. The court till yes, government is to take a decision, government will take a notice on Jatindra Das and money will be returned back to the government. So now, Jatindra Das could have come, or after the judgment in the writ of appeal, the junior college could have come in the name higher secondary school. Who has come now?
Yes.
Now the review petition is filed by, kindly see, madam, governing body of Santilata Mahavidyalaya. After the judgment and the writ of appeal, my full submission is there is no existence of Santilata Mahavidyalaya. Because there is another confusion. There existed degree college and there existed higher secondary school. If he would have said, because that is why I have met the parties, the Santilata, governing body of Santilata Higher Secondary School, alias Santilata Junior College, because they may say it is Junior College, but that is the identification. There exists no Santilata college. So therefore, if this review petitioner will say, yes, I am the secretary of the Santilata Higher Secondary School, it would have been understood, yes, he has come, he has taken the honors. So he has come and he has filed the review petition because he has not been given notice and all these things. But that has not been done in this case. Straight away again with the same prayer, he has come. My respect submission is, it is not acceptable.
Yes.
That is in charge. Because as of now, as per the law, there exists no Santilata Mahavidyalaya.
Well, that part is taken.
That is the only point now I have raised. So therefore, this is the first point. But the second point is, he has not if a third party will come, now he is not a party in the writ petition. A party in the writ petition can file a review or can file an appeal. But if person is not a party in the petition, he has to take leave. either to file an appeal or to leave. There is no leave petition here.
Yes.
So therefore, my response submission is this Manoranjan Behera, who has filed this affidavit, the review petition.
Review petition.
Review petition.
Yes.
The deponent is the Manoranjan Behera, principal cum secretary of Santilata Mahavidyalaya.
Yes.
He has no locus standi to maintain this case because no direction was given to him. It was the person, he strictly would say that Jatindra Das was the principal. If Manoranjan Behera would have stepped into the shoe of Jatindra, suppose now Jatindra is retired, like let us say, Manoranjan stepped into that shoe and he was styling himself as the principal, now he is the Manoranjan is the principal. He could have maintained, but Santilata Mahavidyalaya, not a petition is maintainable because there is no existence of such an institution. Let him file, I say, any communication recently from the government, definitely it should be in Santilata Higher Secondary School. I will also call it, I have asked the clients to collect it. Because this is a communication to them, I can get it at A, but I have not filed, but all the communication everywhere, madam. Official communication are in Higher Secondary School, no where it is there. Because they have to communicate with the direct higher secondary education, there is a different
Higher secondary school or junior college?
Our junior college को होना चाहिए, higher secondary school, सब उड़ा ही है, पर general order है, और junior college को होना. So in this respect, my lord, this is not maintainable. This petition.
Yes.
At instance of this person. Now, my lord, this case at the stage of admission, this review petition, I mean, an interim order was granted to the order. To the order passed in this melody 5316. That was
No course of action shall be taken.
yes.
Natural.
No course of action shall be taken against the petitioner.
Yes.
And there is a submission, Mr. Patnaik and additional government advocate fairly submits that the matter must be held to be sub judice in view of the pendency of the review application. So it is sub judice. He was also fair enough to say we are not taking any action because the matter is sub judice. What action they have taken, madam? How this, and since the House kindly see how the government react and behave in this case. The second writ petition. I'll come to the
Second writ petition is 34074.
again.
Where you have challenged the decision of the government.
Yes. Now, when this order is in force, this interim order, whatever it is, and whatever the submission my friend has made, when the
No course of action was filed because there was some talk of any either a contempt application was filed or the yes probably a contempt application.
Contempt I have filed.
Keeping that in view, that order was
The government, because the secretary was directed to take the decision. So there is no apprehension of the petitioner to take any coercive action. I have filed the contempt against the opinion number one who was directed to decide the issue within a month or
anyway that order was passed.
So whatever the order is order, madam, no coercive against the petitioner, and the submission of the land council was taken note of in the order that since the matter is taken to be sub judice, I infer that yes, definitely no action, no further action in the matter till disposal of the case. But during this order, on 11/9/23, that representation was rejected.
Where is that? 11/9/27.
Page 67.
Yes.
Page 34074.
Yes.
That is why I filed a fresh writ petition. Besides the merit, my response submission is this with reference to this review petition. When there is an interim order to this action, what I have read to my lord, this order, it shows the total non-application of mine, or it can be accepted to be a contempt of this honorable court on the face of it. Whatever he has said, I will place a letter, but on the face of it, it is a contempt of this honorable court. That is my submission, subject to approval.
I think should we continue any further?
Quite okay.
I still sorry only.
Should be clear order.
As per the government notification.
Para 7. No, para 7. As per the government notification, 12 number of teaching and non-teaching employee of the college have received granted benefit under JIO 94 and also granted several block grant under the JIO 2009 in respect of plus 2 of the college. As per the representation dated 11/10/22, it reveals that GIS granted salary was released on 1/7/2009. That is the notification of the college to receive block grant under JIO 2009 is not correct. The above teaching and non-teaching employees of the college have already received benefit of granted under JIO 94 and under JIO 2009, which is prior to the government notification 1/7/2009. Factually incorrect, this I will show. Further, 6 number of employees of the college have received block grant salary under JIO 2009 in respect of plus 3 wing of the college government notification 1/7/2009. There he is coming. How the confusion I will clarify, but I am reading out. To facilitate the drawal of block grant salary of the employees of the college, government have decided for bifurcation of the college in respect of plus 2 and plus 3 wing of the college as separate college, and accordingly 6 number of teaching and non-teaching employees of the college have received block grant salary benefit in respect of plus 3 wing of the college under JIO 2009 after notification government by government order number 219 dated 1/7/2009. The above GIA has been sanctioned and released by the government, which is just and proper, and the question of recovery does not arise. Now what he says is, a particular case, there is a history of this college. But to facilitate drawal of block grant salary, the employees of the college, government have decided to bifurcation of the college in respect of plus 2 plus 3 as a separate college, and accordingly 6 number of teaching and non-teaching employees of the college have received block grant salary benefit in respect of plus 3 of the college and JIO 2009 after notification of government by order dated except no. So in respect of 1/7/2009, the government is admitting we have only paid 6 number of persons. After bifurcating this plus 2 and plus 3 wing. My question is, well, I was representing that the case, there is a governing body. How could the government could have bifurcated and on what basis? That is the only point, because the court has given a restriction while passing the interim order. If anything, if you are losing, you have to return it back. So how could validate the government without giving an opportunity or something like that? I could have clarified. I have paid an order from this honorable court, my representation, but representation while you are deciding, this particular paragraph does not qualify if the purport of the order. If the court has restricted you to not to release, they have to refund it to the state, then the state, yes, all right. End of the day, you may say all these 6 persons are validly appointed in the degree college, therefore they are the employees of that, they are rightly paid. But this finding individual employees have to be done. Therefore, at this juncture, so accordingly he has rejected my petition. In this paragraph, I give only one example out of these 6. He has referred to that name. He has referred to some cases were filed by some person, and in the paragraph 8, kindly see one name. Say na to highlight for you. Pursuant to the order of the Hon'Ble High Court on 20/2004, passed in WPC so-and-so, 37/12 in F4 number so-and-so, WPC number so-and-so, SCT, passed in JK 36, filed by Sri Karunakar Pradhan and others, versus State of Odisha and others. The eligible teaching and not teaching staff granted GI benefit to granted comments so-and-so, communicated by so-and-so. This Karunakar Pradhan, he has not filed this GI, this is a mistake of fact. That Karunakar Pradhan kiya hai. Document kindly see page 71.
Yes.
This there is other dispute pending here. Yesterday also one case was there in the coordinate bench, and that court has taken judicial notice of the fact, what history of this, how the manipulation of this college and all these things. This particular case, I am just telling it example. This Karunakar Pradhan is also there in that case. The entire case in that case, there was a direction of this honorable court. All the appointments have been manufactured. Just to clarify my lord's information. This institution was established, Santilata Mahavidya institution was established in 1980 with one son, the Satrughan Jana agent secretary. That is the undisputed facts. The institution continues. There was no approval. The body who has established the institution, that continues to manage the affairs. All the appointment therefore has to be done by the Satrughan Jana with his signature. There was some dispute when the gratinate came to this institution. So litigations were fought. There was 2 group of persons and all these things. On 27/2/99, gratinate was released in favor of the institution on the basis of a report of a director. Director says a case was filed, WPC 880, what my senior was reading out to my lord. That some dispute, some allegation against the Shatrughan other group, I'm not going to that, but a report has come to the court. They have gone to the college. Shatrughan did not come, he sit in another house nearby to the college. He didn't show any document, therefore, by collecting document for the employees, whoever were there, they have recommended on 5%. The first time on 27/2/19, they got the grantee. But ultimately, this report found place in a judgment of this Hon'Ble Court, that is OJC 880/99. Where is that? Hon'Ble. At source. Hon'Ble. But that report, subsequent stages when complaints, counter complaints, there is a number of cases. Another director given a report, there is a flaw in that report because this out of this 5, initially they got it 5%. One was a teacher of another institution. When he is claiming that I am a lecturer of this college, or Mutunjoy Kohana is a teacher of a Binja High School. Requisition form, everything on record. 2 persons are minors. Those 2 persons who have get granted, they are not even 18 years. Because under the law, under the service code, overage can be condoned, lower age cannot be condoned. So these minors could not have been given the benefit. Their appointment is to be declared null and void. Another person, Jatiman Das himself, he didn't have the 55% mark. At the relevant time, it was 54%. He was only having 47 or 43%, whatever. And another clerk who was given the appointment, he was a student in another college or the same college. I could not recollect. So, but these are the allegations against this 5%. These are the 5% given granted. So, therefore, that was found out. Actually, this further action, after the report of the subsequent director, Partha Sarathi Singh, another audit was directed. And the audit objection found all these things. That yes, how could a minor put got it? How could he? So, therefore, after the audit has come, the government has directed to stop the inquiry and stop their salary. At that moment, they come to this Hon'Ble Court with the help of their entire provision is outsourced. That judgment. Because the director report has given a seal, now nothing can be changed. But under the provision of the Granted Order 94, 2008, every Granted Order will find a paragraph. If something lateral found on suppression of theft, manipulation, then it can be recalled. So that was contested in this Hon'Ble Court when the division then in WPC 2463 of 2010. That Hon'Ble Court didn't interfere. But what the Hon'Ble Court has said, there will be an inquiry in presence of Shatrughan and other persons because they have also intervened, and they will get go on receiving the salary. The director called, the secretary taken the signature of that Shatrughan because that only dispute was Shatrughan never upon some person they are getting granted. Specific signature was taken, but thereafter no proceeding. These 5% they come in a review of that judge. In the review, when they are confronted, they have withdrawn the review. That means the order has to be complied. That inquiry has till date not been completed. This is the position. That yesterday's case was on that. So I am not there. What I am saying is here, this one example only I have to show. Karunakar Pradhan, page 71. This is the signature stated to have been done. This is an appointment order of 21/9/82 in favor of this Karunakar Pradhan. My humble submission is this is a forged document because the signature is not tallied. Forget about my allegation, forgery or no forgery, it is to be tested. Now kindly see, when this person, it said that in that paragraph, read petition file kale, tapre verification nahi diya ho, kaise jinse verification ho, what is the verification report, kindly see, I have given it. In respect of this particular person.
Why is it relevant?
No, relevant in this sense, because I want to say this, because I am challenging now this annexure 9. The report of the director rejecting the representation. No. We have correctly given the 6%. So therefore, no interference, no recovery is required. My responsibility, you have done wrong. You have violated your own orders, own findings.
So anyway, that is to be tested in that writ application.
Yes, that is why it is there. IGT complete karo, paragraph. So kindly see, in respect of this person, Karunakar Pradhan, what are the findings?
No, we cannot. No.
I
got your point. But we are on the review now. We are on the review.
Come back to the review. That is why.
No.
So now,
Please don't digress. Let us come back to the review only.
yes, now review is because my senior friend has my senior, sorry, my senior has stated on merit.
So you say on merit. You all say on merit.
The merit. So now therefore, my respect submission in the review is, when this honorable court passed an interim order, when a submission was made by my friend from the state that yes, the review is there, we will not take any action. So my respect submission, how the same government, over which the statement given to the court means authorities are giving the statement. How could they pass this order? So it is not a review that suppose now a statement was made the 2 dates before by my senior, that if that is the order, after going through the writ petition, I will not press the review petition. So I objected at that moment by saying, by not pressing the review means that order will not, that is has a connection to this order, that is why it has been tagged to this case. So my respect submission therefore is, with regard to the maintainability I have stated, and whatever the merit he has stated with regard to the judgment, I will place.
So we'll take it up next Friday.
Right. Coming to a conclusion, may I?
No, we'll take it up on Friday.
The opinion date. It is a very good point I see. On the last date also, when yesterday also I had pointed out. The
order of this court has been carried out.
No, Santilata Jenna may be directed to file an affidavit saying that the period of incumbency, when she was the secretary of which governing body? Because that
Well, in a review,
the entire case.
No, Mr. Patnaik,
Because why? Sorry, man.
had it been a writ application, yes, your argument is a valid argument. But this is a review.
That
Review scope is very limited.
that in the writ petition itself, my lord, it has been averred that she is the secretary of a particular
So
government.
it is for the secretary to find out. I don't know what the secretary has done.
Registered body.
It is still open to the secretary to find out.
No, we have denied it.
It's up to you. All right, her further arguments, is this matter on next week date? Third. Third May. Yes.
I have a small question, madam. Since I've been hearing about the structures of the institution, let the state council bring to the notice of my law what is the present status of the school, college, whether 2 or 1 or 1 are governing or 2 governing. That is let him get this information.
Yes, in course of hearing, it has been contended that.
I have objection to this. Can we state of this honorable court will direct in this point when the law is there is existence of no composition?
Let him say.
How could he say? How could go to the court?
What is saying what the court cannot do?
No, court, because court is also bound by the law.
No, court is not bound.
Of this honorable court, of judgment decided there is no existence.
I will pass this order, you challenge my order.
No, that's
I will pass this order. I am passing this order.
My endeavor is to the honorable court.
Yes.
To the orders of the division bench of this honorable court, in particular in this case.
Yes.
There exists no composite college.
So let him say so. Let him say so. In course of hearing, it is contended that after passing of the judgment by the division bench in the writ appeal, setting aside the judgment passed by the single judge, there are 2 separate educational institutions, one for higher secondary education and the other for degree. Then State Council is directed to apprise the court appropriately in this regard. That's all. That's
69, I have read it. They have stated, government order rejected.
As I understand.
They have stated facilitated development granting it. Government has decided for bifurcation of the college. They have stated so.
All right. Over and above that, I am passing this on.
Yes. If they will say also, I can file a contempt against them also.
Yes, you file.
You will file an affidavit to court. Yes.
Item 13.
That will take it up on some other day. You have begun in this case. Have you started?
And in this case, my last occasion, my learning senior applicant for state has given an instruction that the governing is a request to state, my lord. So I want some times to take instruction, my lord.
No, on the revision, you said that the file has been misplaced.
And I am
the opposite party number 4 had said that the file has been misplaced. Yes, absolutely. This matter next week. 8th May. Yes. Item 14.
Nobody is there for the petitioner?
I am the petitioner.
You are for the petitioner?
Yes, my lord.
8th May.
My lord, last occasion to filing of a counter last date.
Want to file counter?
Yes, my lord. My lord, now, sir, the copy also copies of the petitioner in court.
Taken up, learning council attends for the university files counter affidavit in the court after serving copy on the other side.
And government also.
Other side though, the counter will be kept on record. Release this matter on 8th, the 8th porota karo. 17th May. Rejoinder if any be filed in the meantime.
Last short date, my lord.
Last 17th May.
Yes, my lord.
Item 15. My lord, 15. I pray, my lord, kindly pass over.
Pass over Ajay Homani, we'll take it up.
My lord, Tuesday.
No, not Tuesday. It will come only on Friday. Yes. If Friday, no, next Friday. 8th May.
Next Friday, death sentence reference hearing.
हाँ हो चलो चलो बहुत मैटर रही Friday. Yes,
my lord.
Yes. Item 16.
Item 16.
That Mr. Mahansu have taken up next week, madam.
Correct. 8th May. You has prayed for Mrs. Matter on 8th May. Item 17.
17 next week.
Next week, all right. 18.
18.
I have also filed the requisite lordship, but they have not appeared before this honorable court.
What happened? What happened?
Last occasion lordship directed.
No counsel has yet appeared.
Lordship.
Nobody has appeared.
Nobody has appeared, lordship.
All right. Despite service of notice, there is no appearance from the side of the opposite party. In order to give an opportunity to the opposite party to appear, we list this matter on 8th May.
Interim order to continue.
Interim order to continue.
Obliged.
Item 19. 19, 20 and 21.
Yes.
My lord, order passed by this honorable court on 19/10/2023. My lord, petitioner filed an interim application prayer for extension of that surrender period.
Well, 2 weeks.
My lord,
in time kar do.
Pardon, my lord.
19/20/21.
19.
Item 17, my lord.
Wait, kindly wait, sir. Kindly wait. Sorry, you're worried. 22. Correction be made accordingly appropriately.
Item 23.
23.
Item 23, my lord. My lord may allow the petitioner to pay the amount in 4 equal installments before the lower court.
Deposit is 1,10,000.
Yes, my lord. Well, his mother is ill and he has no source of income, so my lord may please to grant the petitioner to pay the amount.
By means of this application, the petitioner seeks modification of order dated 31/1/2024 to the extent of permitting him to deposit the sum of rupees 1,10,000 in 4 equal installments. It is submitted that because of financial stringency, the petitioner is unable to arrange the amount at once, but he undertakes to pay the entire amount if some installments are fixed. Stop. What do you say? Land State Council. No, Land State Council has no serious objection to the prayer being allowed. Considering the above facts, the prayer for modification is allowed. It is directed that the petitioner shall deposit rupees 1,10,000 towards cash security in 4 equal monthly installments, with the first installment being paid at the time of release.
Place, my lord.
Item 24.
24, yes.
Modification condition 89, your lordship has allowed 3 petitioners, other 3 petitioners.
Kौन है?
8
petitioner?
Other petitioners are allowed to appear in police station once in Sunday. Here is
Considering the submissions,
it is.
are allowed.
Yes, sir.
Okay.
Old man,
Same order.
no,
Item 25.
कि अफसर भी खाली भी किया ऐसा तो होता नहीं की ना और none appears. Please this matter 1 week after. Yes, item 26.
Item 26.
May I please, your lordship? I have filed an IA for modification of one of the conditions imposed by your lordship.
What condition?
In para 9, first condition, he shall appear personally before the IAC of Koida police station on every Sunday.
Where is it? Where is it? Which order? Dated?
Lordship order dated 18/3/2000.
Oh, yes. What is wrong with it? Why should you?
51 old, 15-year-old man.
51-year-old. Much younger than me.
Having some.
No.
Once in a month, lordship.
Therefore, considering the submissions, therefore modification is allowed to the extent that the petitioner shall appear personally before the IAC of Koida police station on every alternate Sunday at 10 a.m. till submission of charge sheet. Charge sheet has been submitted.
No, lordship.
All right.
Item 27.
None appears 1 week after.
Item 28.
Constitutionally, my lords, take wrongly.
ଆପଣଙ୍କର ଭୁଲ ଥିଲା?
My lords,
Your mistake?
constituted.
Sir, it is your mistake or the court's mistake?
No, our mistake.
The counsel for the petitioner is permitted to correct the
Correction.
typographical error in the cause title of the petition. है ना? तापरे कौन ଅଛି?
Surrender data.
Whereupon have you taken certified copy?
My lords.
Have you taken certified copy?
My lords.
Certified copy be submitted for necessary correction. Then what? 2 weeks further time is allowed?
My lords.
Yes.
Item 29.
29.
This is for extension of time to surrender.
First time?
First time.
2 weeks time.
My obliged.
Just don't.
Item 27, extension of time I filed.
29.
27, my lord.
27.
Yes, my lord. Next.
Is it for the first time?
First time, my lord.
All right, 2 weeks time. There was some other mention, item 17. Yes. What item 17? Yes, what is this?
My lord,
Instead of filing requisite, so issue by speed post, by registered post. Why did you file by registered post?
this is not my case, my lord. My senior will apply this case.
So then don't come. Let it come next week.
Special notice.
May I? The extension of interim order, madam. Interim
bail.
Interim bail, madam. It is not mother is not seriously, man. Is my lord.
ये sign है, no sign है. केमती? साड़ी क्यों नहीं? Already once you have it has been extended.
Mine. First time he has admitted in.
Considering the fact that considering the submission that the petitioner's mother has not recovered fully and is under treatment, the interim bail granted by order dated 2012-2023 and extended by order dated 22/3/2024 is further extended by a period of 2 weeks.
1 month or
All right, 1 month. It is made clear that no further extension shall be granted.
In course of the day, minor copy, 27 is the surrender.
Minor copy be granted in course of the day.
Item 17. Your lordship directed to take notice on speedy post. Wrongly, my clerk has filed this on resty post authority.
Remove the clerk immediately. Remove the clerk. Don't keep him.
Lordship, accept.
No, no.
Then I will take notice.
Yes.
Press notice.
It is submitted that inadvertently the requisites were filed for issuance of notice by registered post instead of speed post as directed. Stop. Sri Boral, this is not your matter, Mr. Boral?
Yes,
Sri Boral and counsel for the I1 का नाम लिखा है इसी? Sri Boral, counsel for the petitioner undertakes to file the requisites for issuance of notice by speed post by Monday.
By Monday.
If such requisites are filed by Monday peremptorily.
Yes, sir.
Peremptorily.
Yes.
Notice be issued, fixing a short returnable date. Is this matter on?
17th May.
Oh, yeah, 17th May. 17th May, interim order to continue.
No extension of time, item 25.
Item?
25. No extension of time.
Has it come for the first time?
No.
First time I would extension 2 weeks for the time. Yes. How? Yes, Mr. Mishra, you are waiting?
That special mention matter.
Hmm.
That you will also trying to grant 1 month extension. Because he has medical discharge referral certificate he has given. That is disease is anxiety. I have taken instruction from the medical doctor that
I have said that no further extensions shall be granted.
ନାଇଁ ମୁଁ ଯାଇଥିଲି ଡକ୍ଟରଙ୍କୁ ଦେଖୁଛି what is this disease whether surgery is required so this is anxiety for that reason he has filed.
Well, so second half we have only second appeals, the 2 second appeals. List is over.
My Lord, I am D.K. Sahu, appearing on behalf of Mr. K.C. Kaur, counsel for appellants.
Decision section ଆସିନି ଖାଲି xerox ଟା ହେଇଛି
Sir, Madhavananda Sahu, respondent number 1. The legal details.
When did he die?
Sir, he was died on 8th August 2023.
This is in time.
Sir, it is on time.
You have to file probably.
In IN number 1260 of 23.
Substitution of legal. What is this?
So this is for one of the legal hair. Her name has not been mentioned there. So you know to add. That.
This is another 1260 has not been.
No, sir. First time, sir, I thought.
1260 of the problem. 499 of the document. It is
these petitions for substitution have been filed. As respondent number 1, Madhavananda Sahu, is said to have died on 8/8/2020. It is submitted that right to survive in the world of legal rights. Entered in the schedule. In IN number 499 of 2024, the name of the widow of the deceased, respondent number 1, where is Martha Sahu, was inadvertently not mentioned.
My lord. My lord, I may be permitted to correct the names of a legal representative of serial number 3. Right.
Considering the fact that the application for substitution has been filed within time, or was in the law. Question number 1, being deceased, is substituted by the legal representative mentioned in the schedule to IN number 1260 of 2023 and IN number 499 of 2024.
Yes.
As respondent numbers 1, 8 and B. How would come with it?
Sir, is serial number 3, that is Bini Sahu in IA 1260. That may be corrected to Binita Sahu.
Yeah, by hand process. By hand process. The concept of the appellant is permitted to correct the name of the Ella Bini Sahu.
And sir,
in the schedule to IA 1260 of 2023 in court.
and sir, जो item 4 कालंदी साहू आज सोमनाथ साहू. Sir, 4 item 4 serial 4.
Name of Kalandy Sahu be corrected as
Somanath Sahu.
Somanas Sahu in court. Yes. No. You can notice to the as they are record.
Sir.
The notice has been issued.
Yeah.
You can notice of the appeal. It has not been admitted.
No, sir.
Not been admitted.
No.
Admitted today. This is with materiality.
No, sir. My senior.
This is not for admission. This is asking for admission.
Commencing the first July.
We commencing first July.
Oblige.
So item number 8. Item number 9.
Yesterday what happened? There is no appearance.
No.
I know.
Sorry. Sir, you are Mr. Naik.
Bikanak.
Yeah. Sri Bikanak, learned counsel for the appellant is present. There is no appearance from the side of the respondent on repeated calls. Yesterday also, the matter being in the weekly list for 25/4/2024 and 26/4/2024. 26/4/2024, comma. The matter was called out yesterday, but there was no appearance from the side of the respondent. So, since this is an appeal of the year 2016, I find no reason to keep it pending further. Stop. Heard arguments from the side of the appellant, judgment reserved. Item 10 was also same. Item 10 the same order. Huh?
Item 10.
At item 10, Mr. Bhante had argued it yesterday.
6 minutes ago.
Huh?
6 minutes ago.
Ji, Arjun ji.
Commencing 6.
Item 10 है? Arjun ji. अच्छा अच्छा.
আচ্ছা 12টা পাঠান।
I don't know 12.
12টা বিষয় করতে 12টা যে অর্ডারটা পাস করলি সেটা করবে। তারপরে yes Mr. Mishra, you are waiting for which matter?
19.
Item 19.
19. Yes.
I am for the respondent here.
Yes, somebody yesterday made a mention on behalf of the appellant probably,
Yes, yes.
isn't it?
No, yes, he has not come. That is a very interesting case. Let me place the case.
But the appellant is not there. All right, you may place it.
Only I have to let him come.
Yes, I'll take it to next week. Next week, sir, you go. Yes, go on.
Very interesting case here. The plaintiff prays for to cancel the sale deed, to declare a sale deed, that is 121 of 5113, executed by defendant number 2 in favor of defendant number 1. Here is the respondent number 2 and respondent number 1 in the appeals. Second prayer is, let the defendant, more particularly defendant number 1, be permanently restrained from creating any disturbance over the Schedule B property in any manner, and also restrained to obstruct the use of plaintiff over the same, and also from making any forcible construction on the suit land by changing its nature and character. And the entire pleading is based on easemental right, but there is no prayer for easemental right, and there is no declaration to that the Schedule B land should be declared as easement. He has a road in the western side of the land, that he has got the land basing on that a suit was filed, that is TS number 160 of 94 on adverse possession against the defendant number 2, is respondent number 2 here. That suit was decreed basing on the Panchayat Faisalanama. There also the easement was never declared by the court. That the trial court in that judgment that was passed on 23/9/94, there also easement was not declared. Only the claim was there for declaration of that adverse possession of 70 decimil of land. And that was decreed basing on the Panchayat Faisalanama.
Yes.
Panchayat Faisalanama, there is nothing was mentioned about easement about B schedule land.
Yes.
There in the land schedule, and there with the boundary description, there are 3 things. Uttarare Chandramani Bariko, Dakhinare Mahendra Lenka, Purbore Gharoi Rasta, Paschimore Rasta. Paschima Rasta is a public road.
Achha.
Purbo Rasta, jota Purbore achi Gharoi Rasta, it is not for easement. That the original owner never given that land to anybody, and neither the neighbors nor to the that plaintiff or the appellant.
Who are you?
I am the respondent number 2.
Ajay Kumar Sahu.
No, Ajay Kumar Sahu is the owner of the land.
So you
I am
are
one. Respondent 1.
Kusuma Manjari Rana.
Yes, that is Kusuma Manjari Rana.
No.
Yes, my claim is also based on that another suit. There are 4 persons, those who have claimed adverse possession over Ajay Maharana. One is suit number 160 of 94, that is exhibit 1. Then exhibit 2 is TS number 429 of 95. That is on my suit. I have filed a suit against the Ajay Maharana, Ajay Kumar Sahu, and that was decreed for 20 decibel. That is adverse possession based on the Panchayat Faisalanama. And another 2 person neighbors, they have also filed 2 suits. That is one Raghunath Sahu, he has also filed a suit against Ajay Kumar Sahu about 80 decibel of hand. That was also declared, and that was ended with a compromise basing on the Panchayat Faisalanama. And the 4th suit is 491 of 2002. That was filed by one Judicial Bosa against Ajay Kumar Sahu. That is Total area is 55 decibel.
Ajay Kumar Sahu is the original owner.
Original owner.
Yes.
Against whom 4 suits are filed.
So he sold the property to?
He has sold the property to defense 4 persons.
So including you?
Yes, that is decided on the 4 suits in 94.
Yes, yes, all right.
Yes. That B scheduled land was sold to me in a, that is on dated that is on dated 5/1/13. 5/1/13 जो सेल डिक्ट आला, he has challenged that cell dict.
Who is the plaintiff?
Plaintiff. And the trial court, without any prayer, without any pleadings, whether it is a right of easement on prescription or easement on necessity, there is nothing. But given the findings and allowed the prayer of the plaintiff that the schedule B land is the easement right of.
So let us see the judgment of the trial court.
Trial court judgment, Lordship may see, that is in the second appeal. Yes, annexer 2.
3-4 pages sir दीजिए.
Annexer
23/9/1994.
Yes.
The judgment is
23/11/19, date of judgment. Trial court judgment.
Trial court judgment is on 23 देखा जाओ इस
judgment is 13/11/19.
देखा जाओ बिल्कुल 30/11/2019.
Yes.
Before the additional civil judge. Yes.
Yes. Very interesting here, Lordship may see.
Let us see the issue.
Page 46, that findings of that court. I am placing the last paragraph.
Page 46 of the informed judge.
Yes, in this regard, on going through the evidence of the parties.
Just a moment, sir.
In this regard, on going through the evidence of the parties.
Yes.
Yes. As well as on the specific perusal judgment passed in the court, that is exhibit 1, 2, 8 and 9. 1, 2, 8 and 9 is the exhibit that suit of 94. There nothing was mentioned about the easement.
Yes.
Only boundary was described. There is also no specific mention of that easement. Basing on that 4 judgments, he has passed the judgment and decree in favor of the Lordship may see this what is stated. That is exhibit 1, 2, 8 and 9 in favor of Sanjukta Swai, Kusuma Manjari Rana. Sanjukta Swai is the plaintiff.
You are Kusuma Manjari Rana.
Yes, Kusuma Manjari Rana. I am the dependent number 1. There are other 2 are Raghunath Sahu and Judhishthira Vasa, the neighbors. It is found that the suit schedule B land is reflected as a road in the sketch map attached to the judgment. The defendant number 1 also admitted the contents of all judgments as true. She has also not challenged the findings of the court before any forum. In the said judgment also the boundary description of the respective land is also mentioned where it is reflected as a road both eastern and western side of the plot. The defendant number 1 also admitted in her evidence that she has not constructed any house over the Schedule B land. Therefore, after going through the discussion made above, it is found that the road as mentioned in the suit Schedule B land is used by the plaintiff as easement right of way for which the sale deed executed by defendant number 2 in favor of defendant number 1 is void and illegal. 1 and no right is accrued to defendant number 1 by virtue of the sale deed. As the land, as the suit land is used as easement right of way of the plaintiff, the defendant number 1 is restrained permanently from making any construction as well as obstruction over the Schedule B land. Accordingly, these issues are answered affirmatively. Now, Lordship may see the issues. here also mentioned issues, Lordship may see that judgment.
Yes.
There is no issue is framed with regard to easement. Lordship may see 2, 3, 4 and 5.
Yes.
These four issues wherein that incidentally that the trial court has decided that easement are right. Not a particular issue with respect to easement was framed. Lordship may see this.
It was whether the cell deed bearing number so and so.
Only cell deed. Declaration whether the cell deed bearing number 121, 5, 113 executed by defendant number 2 in favor of defendant number 1 is illegal, void or inoperative or not. Whether a decree can be passed restraining the defendant number 1 permanently for causing any disturbance over B schedule property. Whether the plaintiff are entitled to cost of the suit and whether the plaintiff are entitled to any other.
So now the suit was decreed on this finding.
Yes, trial court decreed. So it is reversed by the district judge.
Let us go
Thereafter second appeal.
Let us go to the judgment of the district judge.
Yes. Now, Lordship may see that he has based his claims on that the judgment of trials TS number 160 of 94.
No, shall we look at the lower court, lower appellate court judgment?
Appellate court, yes. Lordship. That is annexer.
Yeah, annexer 1, I've got it.
Yes. Para 14 I am placing.
Yes.
From the above findings of the learned court below, it appears that learned court below came to a conclusion with the view that easementary right of way of plaintiff over suit schedule B property was granted in judgment and decree number TS number 160 of 94 marked as Exhibit 1, TS number 429 of 95 marked as Exhibit 2, TS number 14 of 95 marked as Exhibit 8, and the decree in CS number 491 by 2002 marked Exhibit 9, but the defendant being appellant claimed before this court that no such right of easement is granted or declared in the above civil suits by TS number 160, the wrong is 168, 160 of 94, TS 14 of 95. Hence, the court has carefully examined all the certified copies relating to aforesaid decrees and found that present plaintiff, the defendant number 1 or one Raghunath Sahu and one Judhishthira Sahu being plaintiff filed TS number 160 of 94, TS 429 of 95, TS 14 of 95 and CS 491 of 2002 against the present defendant number 2 for declaration of right over the property described in the respective suit. On perusal of the above judgment and decree in the aforesaid suit, it appears that all the above suits are decreed by accepting the award submitted by arbitrator Panchayat Faislanama as a part of the decree. This court also carefully examined the award sheet of TS 160 of 94 and TS 429 of 95 and found that though in the said award the ownership of plaintiff and defendant number 1 over suit schedule A property and defendant number residential area were allotted by showing boundary description of their respective plots. But in the said award sheet there is no such wording about grant of schedule B property to the plaintiff for use of passage. At this stage, learned counsel for the plaintiff argued that the description of the property in the award sheet of TS 160 of 94 and TS 429 of 95 itself reveals the existence of passage schedule B property. Therefore, learned court below rightly held the plaintiff has a right of passage over the same. Hence, this court carefully examined the description of schedule A property available in the award sheet attached to the decree of TS number 160 of 94 and found that though the said award sheet shows there was a road on both eastern and western side of the present plaintiff allotted area, that is suit schedule A property, but the road on eastern side was shown as Gorai Rasta. Therefore, question arises whether such description in the award sheet attached to the decree of TS 160/94 itself is enough to prove the plaintiff's claims of right of easement over the said Gharoi Rasta. But interestingly, from the pleadings of the plaintiff, it appears that the Kisama of the schedule A property, that is property allotted through the award sheet attached to TS number 160 of 94, was first time converted to homestead land in the year 2011 by virtue of order passed in OLR case number 282 of 2011. Whereas the award sheet attached to TS number 160 of 94 shows the same was prepared on 2-3-94. Hence, it is well appeared that there is no existence of house of plaintiff at the time of preparation of award sheet dated 2-3-94, which is made as a part of the decree in TS number 160 of 94. Therefore, in such circumstances, it cannot be said that the said Gharoi Rasta shown on the property description of Schedule A in the award sheet available in TS decree number TS 160 of 94 is meant for the plaintiff used to ingress and egress to her homestead land. During the argument, learned counsel for the plaintiff further raised that executing an agreement, the original owner Ajoy Kumar Sahu grant right of way over Schedule B property.
Mr. Mishra, I will stop you for the moment because there's very less time. And he has also appeared.
Yes.
He has also come. So the trial court's judgment was this finding about the easement was reversed.
Yes.
Relying upon on the recitals of the award sheet.
Yes.
He has himself read it and says that there is no such thing as easementary right.
Yes.
This is the finding. Yes, you are challenging it on what ground?
Your Lordship, before I start, Your Lordship, I may request Your Lordship, my learned senior has to argue this matter. Actually, this matter has already been argued by my learned senior before the coordinate bench. He's today on his legs, Your Lordship. So, Your Lordship, may keep it to Monday, Your Lordship. Your Lordship.
I'll keep it to next week. It will come next week. All right. It is a heard in part. I'll treat it as a part heard matter.
Your Lordship.
All right.
Your Lordship.
Heard in part. Let's this matter next week. But next last दिन हमारा शो in the weekly list. It will be there in the weekly list as a part heard matter. All right.
I'm obliged.
गुरुवार शुक्रवार तो आसची
गुरुवार शुक्रवार ଆସିବ.
I'm obliged.
All right.
से जो एग्रीमेंट भी से कहउछन से एग्रीमेंट भी प्रूव हेनी तो ग्रांट कहउछन सेटा भी प्रूव हे नै तापरे आइदर जदि प्रेस्क्रिप्शन आसीओ 20 इयर्स देखेबे सूट पूर्वरु 20 इयर्स एवं सूट फाइल हवर 2 वर्ष पूर्वरु that should be completed according to the easement section 15 तेणु सीए देखौछन जो एग्रीमेंट আছে 1994 एग्रीमेंट एग्जिबिट 3 टा जस्ट लॉट में
I have closed it. So let us agree come next week.
एग्जिबिट 3 टा 94 देखौछन या प्लीडिंग से 94 अछि किंतु से कहउछन सेटा रॉन्गली हिच जैसे 97 बोली किंतु 94 देखिया गले से 20 इयर्स में 2017 में फाइल कलो सूट ए जो सूट आसला सेकंड अपिल 17 ने ता पूर्व 20 इयर्स देखले 94 आसीओ 94 ता ताका प्लीडिंग से भी अछि that exhibit 3 someone execute हेतला 93 ये 94 रे एठी जे दस्खत करछन 97 ने से भी आसी केटो प्रूव करना से भी स्ट्रेंजर
Okay. All right, we'll see that.
Yes, that it is a false document. Learned appellate court also held. It is a false document.
So it is part heard. Okay.
Your Lordship, I am obliged.
Mr. Mahathir, I have closed that matter. I have said that. Kena to कौन करेगी?
ठीक है
This तो wait करी होगा नहीं. So I have closed it. I have kept it for reserve for judgment. You may file your note of submissions within 3 days. Note of submissions and memo citations within 3 days. So these are going to
होई दोछ
even.
आउट कमिशनर रिपोर्ट यूज फील्ड इंक्वायरी पे appellate court पठै दिले से भी कहले बी शेड्यूल लैंड रे कोनसी रोड नाही appellate court से सेंड कमिशन ओनली वेस्टर्न साइड रे रही रोड जोटा पब्लिक रोड इज यूजिंग जदि गोटे रहिला ये रोड ताले इजिमेंट कैन नॉट बी क्लेम्ड.
All right, since it's a reversing judgment, let them place it. Yes. Any other matter? No, list is complete. All right.